Hello entrepreneurs, it's Michael Mort with Argent Place Law, the law firm for entrepreneurs, where we're looking out for you. And one of the ways we do that is to make sure you understand what limited liability means when you form a corporation or a limited liability company. How does that affect you if one of your employees does something wrong? So you may have heard recently, as a matter of fact just a few days ago, that Tiger Woods was named in a wrongful death suit. You see, Tiger owns a restaurant in Jupiter, Florida called The Woods, and one of his employees overdrank after work, and then on the way home, he drove himself home, and unfortunately, he passed away in a massive automobile accident. Tragedy, but the estate for the decedent filed a lawsuit against The Woods, the restaurant, and also against Tiger Woods personally. So that really alarmed me. I said, Tiger Woods was named personally in a lawsuit because he's the owner of a corporation. Somebody in the corporation did something wrong and Tiger Woods is named in this lawsuit. How can this be? So I got a copy of the complaint that was filed. And I looked through it, and it alleges a lot of things, but among them is something I want to read to you. Here's what the lawyer wrote. Here's what the lawyer for the plaintiff wrote. Tiger was directly responsible for ensuring that his employees and management at his flagship restaurant were not over-serving its employees/customers. And then it goes on to give a citation to a Florida case, which supposedly confirms that this creates a liability for Tiger Woods as the owner. So I looked up that case because I can't believe this is true. Can you imagine what would happen if this were the situation, that owners were responsible for what employees of their company did? This goes against everything we know about limited liability and the whole reason that limited liability companies and corporations exist, to shield the owners from the fault of their employees. Well, it turns out that the case that's cited here, it's called White versus Walmart Stores Incorporated. This case goes to say exactly the opposite of what the plaintiff's attorney claims it says. Let me read you these two parts. The first is kind of alarming, but then I'll read the second part. So the first part says, the law is clear to the effect that officers or agents of corporations may be individually liable in tort if they commit or participate in a tort, even if their acts are within the course and scope of their employment. What does that mean? The tort is any bad act. In this case, the bad act was bartenders serving this employee after his shift was over, serving him too much, and he got drunk, and then they didn't keep him out of his car. They let him go drive home, and he ended up killing himself in an automobile accident. So the bad act was serving him too much and then letting him go home without stopping him. In this case, who participated in that tort is important. Who participated in that bad act is the important thing, because here's the second part of what's in this case that was cited by the plaintiff's attorney. It says, however, to establish that liability, the complaining party must allege and prove that the officer or agent of the corporation owed a duty to the complaining party and that the duty was breached through personal fault, not vicarious or technical fault. Vicarious fault is the fault of an employer when an employee does something bad. That's vicarious fault. The employer is always at fault when an employee does something bad. So the restaurant owes a duty to its customers, in this case to this customer that drank too much and ultimately ended up killing himself in an automobile accident, because one of the corporation's, the restaurant's employees, a bartender, served this guy too much to drink. But is the owner responsible? No. It says that the officers and agents have to have participated in this tort directly through personal fault, not vicarious fault. So I feel confident that this part, at least, of this complaint will be thrown out, and that we're not going to establish some kind of new precedent that the owners of corporations or limited liability companies are automatically liable when the employees, one or more employees of the corporation, do something wrong. Sometimes lawyers overreach. And in this case, perhaps this was done just to get Tiger in a vice and say, you know what, we're going to allege this stuff and it's all going to come out. We're going to sue you personally, and therefore you have to settle with us. I don't think you need to worry, as I originally did when I saw this. You don't have to worry that there's somehow going to be an overturning of this whole concept of limited liability for owners of corporations and limited liability companies. So take a deep breath and go on. But of course, you want to do the best you can so that educate your employees so that they don't commit bad acts. But if they do, and you're not individually participating in those bad acts, you, the owner, are not going to be held responsible. Once again, it's Michael Mort from Argent Place Law, the law firm for entrepreneurs, where we're looking out for you. Thanks for listening.